In this segment, I will discuss the abuses of the courts. I believe our courts today, like Congress and the President, have grossly overstepped their constitutional bounds. I've already discussed how today we have accepted the idea that the courts are the final authority in everything, that the Constitution is what the judges say it is. Since we believe that, the courts have been able to change the Constitution arbitrarily by judicial fiat. Did we always treat the courts as supreme? What did our founders think of the courts, and what was their intent in the design of the courts? As always, I go back to the original intent of the Constitution. Article 3 of the Constitution deals with the courts. You will find nothing in that gives the courts the final authority. In fact, you see that their sole job is to judge cases as to law and the fact, and not to make national policy or laws of the land. Let's look at some history. First, the question of judicial review, meaning the court's authority to declare laws of Congress unconstitutional, was one of the most contested issues of the Constitution. I could give several quotes from founders that declare that the judiciary does not have the right of judicial review, and others that say they do. It is not specified clearly in the Constitution. There were plenty of debates falling on both sides of the issue. There was not a general consensus that the courts did have this authority. Even those who granted the power of judicial review, they did not think the judges were to be the ultimate authority on the Constitution. Hamilton was one who believed the courts did have the power of judicial review. But in Federalist number 78, Hamilton demonstrates the design weakness of the judiciary. He said the judiciary, from the nature of its function, will always be the least dangerous to the political rights of the Constitution, because it will be the least in capacity to annoy or injure them. The judiciary has no influence on either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm for the efficacy of its judgments. The simple view of the matter suggests several important consequences. It proves incontestably that the judiciary is beyond comparison the weakest of the three departments of power, that it can never attack with success either of the other two, and that all possible care is requisite to enable it to defend itself against their attacks. It equally proves that though individual oppression may now and then proceed from the courts of the justice, the general liberty of the people can never be endangered from that quarter. Well, Hamilton got that one wrong, or did he? Well, he got it right if the court stayed within the bounds of the Constitution, and we are the ones that have it wrong. The founders never intended that the courts would be the final authority. In the same Federalist Paper number 78, Hamilton affirmed the courts could make judicial reviews of the laws of Congress, but he also affirmed that this did not make the judiciary superior to Congress. He argued that all branches of the government were subject to the constraints of the Constitution, and that the people were the ultimate authority. Madison concurred. He said, but the great objection drawn from the source to which the last arguments would lead us is that the legislative itself has no right to expound the Constitution. That whenever its meaning is doubtful, you must leave it to take its course until the judiciary is called upon to declare its meaning. I acknowledge in the ordinary course of government that the exposition of the laws and Constitution devolve upon the judiciary, but I beg to know upon what principle it can be contended that any one department draws from the Constitution greater powers than another in marking out the limits of the powers of the several departments. Jefferson also agreed. He said, "You seem to consider the judges as the ultimate arbiters of constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Each of the three departments has equally the right to decide for itself what is the duty under the Constitution without any regard to what the others may have decided for themselves under similar questions. In the case that supposedly established judicial review, Marbury versus Madison, Jefferson, as president, in essence ignored the court's ruling. The court wasn't even upset. It was Jefferson's prerogative to do that. In fact, the court designed its opinion on a technicality so that Jefferson couldn't object and the court could save face. Also, not once from 1803, when this case was decided, until 1857, did the courts declare any act of Congress unconstitutional. That makes you wonder whether the modern interpretation of this case establishing judicial review is valid. It was really John Marshall, in writing the opinion for Marbury, who deviated from the consensus of the time. Marshall was among a small group of individuals who wanted more of a centralized government rather than the federal system that was ratified by the states. In order to grow the power of the central government, Marshall claimed the power of judicial review for the courts. This started the long and slow process of the growth of the national government to dominate the states, which was not in the intent of the Constitution. More on this in a later segment. When the court made a ruling against President Jackson in Georgia versus Cherokee Nation, he stated, "The court, or really John Marshall, has made his ruling. Now let them enforce it." Jackson then ignored the ruling. President Andrew Jackson's philosophy on the Constitution was summed up in this statement. He said, "Each public officer who takes an oath to support the Constitution swears that he will support it as he understands it, and not as it is understood by others. The authority of the Supreme Court must not, therefore, be permitted to control the Congress or the executive." President Lincoln agreed with that philosophy. He said, "I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court. At the same time, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by the decisions of the Supreme Court, the instant they are made, the people will have ceased to be their own rulers, having resigned their government into the hand of that eminent tribunal." Lincoln then ignored the Dred Scott decision of the court that declared that all slaves were property and issued the Emancipation Proclamation. The left has used the courts almost exclusively in the last 100 years to further their agenda. Why? Because they would never get their agenda passed through the normal process of lawmaking. Take the homosexual agenda or abortion or any number of liberal issues. They have always been forced on the people by activist courts who ignore the original intent and clear meaning of the Constitution. With their newfound powers, the courts have intruded into all areas of our society, finding new so-called rights where they didn't exist before, like abortion in Roe v. Wade, and making edicts that are only the purview of the legislative branch, like forced busing in Swan versus Charlotte-Mecklenburg Board of Education. In that case and many others, the courts made law by imposing what they thought the answer to a problem was, instead of allowing the Congress or the state legislatures to make the law. They have stripped the states of their constitutional rights to rule on everything not specifically granted to the federal government. They have, in essence, changed the whole Constitution without an amendment. In my opinion, the biggest abuses from the courts have come in their interpretation of the First Amendment. I will cover that in another segment. Now, what is the answer for the abuse of the courts? First, there must be a change in philosophy. We need to understand our system of checks and balances. The court should not be the sole unchecked power in our system. By design, when Congress passes a bill, they are declaring they believe the law is constitutional. When the president signs a bill into law, he is also declaring the same thing. If the courts say differently, Congress and the president can reevaluate their decisions, but if they disagree with the court, then they have the power to ignore those decisions or repass the law. I'm not suggesting we ignore the Supreme Court all the time, but in cases that are obvious violations of the Constitution and the principles of the Declaration, it is the duty of the executive, Congress, and the states to protect the people by ignoring or overturning those rulings. There are several congressional remedies built into our Constitution to combat judicial abuses. Congress has constitutional control of the courts and can abolish all lower courts. Congress has used this in the past where they disbanded a lower court one day, getting rid of all the judges on those courts, and then reinstating those courts shortly after. Article 3, Section 1 says, "The judicial power of the U.S. shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." Congress can get rid of the bad judges through impeachment. Contrary to current teaching that judges hold their seats for life, they sit in office only during good behavior. Article 3, Section 1 says judges shall hold their office during good behavior. Congress has in the past used the impeachment process against judges for various reasons, including making decisions that Congress believed was unconstitutional. Congress can also rule a particular subject off limits for the courts. What? Yes, that is true. Article 3, Section 2 says, "In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, but as to law and effect, with such exceptions and under such regulations as the Congress shall make." That is exactly what happened after the Civil War. After Congress passed the Reconstruction Acts, they were afraid the Supreme Court would declare these acts unconstitutional. Why? Because the court still had Southern sympathies left over from the Dred Scott case. So they passed a law disallowing the courts from making judgments on the Reconstruction Acts. When this action was challenged in the courts, the Supreme Court actually voted unanimously that Congress had this authority. Unfortunately, Congress has not had the courage to use any of these methods of restraining the courts in over 100 years. Beyond Congress, our state governments must not acquiesce to the unconstitutional rulings of the court to maintain our federal system of checks and balances of the national government. I will discuss that, what is called interposition, in another segment. In conclusion, the more people who understand that the courts are not the ultimate authority, the less they will get away with their distortions of the Constitution. We, the people, must act to elect governors, representatives, and congressmen who will not bow to the courts when they are wrong.